thank you all for spending your lunch hour talking about what I'm sure is everyone's favorite topic, e-discovery. So before we get into our topics of discussion, we'll introduce ourselves. I'm Deeva. I'm a partner here at KVP. I love cases that involve complex novel technology. I generally specialize in IP and patent disputes. But with those complex technical disputes comes complex discovery, especially when it comes to larger companies, but now even smaller companies that have access to a number of ESI tools and enterprise tools that can get really thorny. And also with novel technology means we have novel e-discovery disputes. And so these types of disputes are constantly changing. And so for today's presentation, we'll really be focusing on some of those novel issues that have come up in the last few years for e-discovery and also how to address those. Before I go on, I'll let Melissa and Ryan introduce themselves.
Perfect. Hi, everyone. My name is Melissa Cordial. I recently joined KVP, and I'm excited to be here with you all today to discuss e-discovery.
And my name is Ryan Peterson. I'm one of the e-discovery attorneys here at Keker. I've been in the e-discovery space since 2008, and I've done just about every role you can think of in this space. So I try to bring all of that to bear as we're working with our clients on these complex issues.
So the reason you're getting the three of us today is because we've been through a number of thorny discovery fights together. Melissa has developed an expertise in implementing multi-factored lit holds, parsing through complicated privilege issues, and managing collection from a wide range of sources. And Ryan, as he just mentioned, brings us decades of experience, including putting together things like model ESI orders, managing e-discovery issues in very complex cases, and also going through countless novel issues related to preservation, collection, review, and production. So as much as the three of us love trial litigation, that's why we're at KVP, getting to trial really means a lot more time is spent in discovery. And so understandably, clients have a number of concerns about producing documents and communications in that process. Confidentiality concerns, scope, security, burden. And our clients need to balance all of those issues with their obligations under the law also in the discovery process. And so the point of today's presentation is first going to be to explain what those obligations are with some of the newer technologies that have been coming up, especially, but also how to enact policies and procedures that would limit the burden or the scope of potential collection. And so having thoughtful procedures to limit ESI orders and having drafted PO language is really the best way to avoid litigation costs and these one-off fights that frequently happen in the discovery process, and to also limit the amount of things that you may need to produce in the litigation process by being thoughtful from the very beginning about how you're implementing your litigation holds and a number of other things. So just a brief preview, if we can go to the next slide. We'll be talking about litigation holds and what that means, especially with newer technology. We'll be discussing ESI orders and protective orders. And then we'll end with something that the last group just left off on a little bit, which is AI use. And specifically, we'll talk about privilege issues and also about other litigation hold type issues that come up with AI. So I'll start with litigation holds. Next slide, and we can actually skip through the intro there. So I'll start off with litigation holds. I think many folks have probably had to deal with these holds at one point in time, but the goal here is when you are sued, you need to send out a litigation hold for your company if you're working in-house. And if you're not working in-house, then you likely will have to advise someone to potentially send out a litigation hold. And the goal here is to be clear, specific, and actionable. Because in order to actually get out this notice and have it be effective, have it be something you can rely on throughout litigation, it needs to be clear to the individual who receives it what they need to be doing and how they need to do those things in terms of making sure that they're preserving documents, they're preserving communications, and they're preserving information that is relevant to the litigation. And litigation holds can on the front end seem like a fairly heavy lift, depending on how big your case is and how many years it'll cover and the topics it'll cover. But what litigation holds can do is provide a backstop. So if there are ever questions about what was preserved, what information exists, Having a thorough litigation hold in place is the best way to cut off a number of potential sanctions, cut off a number of questions from the other side about what was actually preserved. And to be clear, when we talk about litigation holds, we're talking about preservation, not about collection, and definitely not about production. So just having to put something on hold does not mean you need to produce it or even collect it necessarily. So in terms of litigation hold notices, you want to include a description of the matter, enough information so that these individuals who are receiving the hold recognize what's relevant, who the key parties are. The key parties might not just be the parties in the litigation, but there might be third parties involved, and that's important to consider. What the issues are and the time frame is for the hold. And the time frame won't just be sort of exactly what's spelled out in the complaint, but you should maybe think a little bit more about which facts are at issue. So is there going to be product development that's at issue that maybe isn't spelled out? Thinking a little bit broader, especially when it comes to ESI, is particularly important because when you implement that litigation hold, you'll both be doing it at an individual level, but also at a system-wide level. And so you'll need to make decisions about timing. Also, scope of information is important. So when you send out a litigation hold notice to individuals, you want to tell them this doesn't just cover sort of the obvious things like emails or documents within their possession, but things that are in databases potentially might be impacted. Spreadsheets, ephemeral messaging apps, Slack, Teams, voicemails, cloud storage. So this is both ESI, electronic information, and paper records, but also the location and the format may change. And Ryan's going to get into this a little bit more. When you talk about what types of ESI might be included in preservation, you want to think through as many of those types as possible and make sure that if it's a custodial source, meaning if an individual is saving it in some way, organizing it, storing it in some way, that individual is aware if they're on the litigation hold that they need to take efforts to preserve that information and also make sure that they're not, they don't have any deletion practices in place already at an individual level. When we're talking about the preservation instructions, you want to make sure that an individual especially knows that they should suspend deletion policies that they have in place, but then also practices. Sometimes you might have an individual who's used to, for example, deleting emails after they read them. And that's the sort of thing where you want to advise people that if they have a practice of doing something, they should also stop doing that in order to make sure that an entity can meet their ongoing obligation. Finally, you want to have a point of contact. People will have questions, and especially if you're working with a client or with individuals who haven't gone through litigation before, litigation hold notices can be a little bit terrifying, and they won't really know exactly how to put a lot of these policies into place. For example, people sometimes are just not aware if they have a text message deletion policy that their phone is already using and that their messages will delete after a certain point of time. And the other important thing to remind individuals of, but also as an entity, is to think about where relevant data may reside, and let them know who the point of contact might be if they have questions about that. That means involving IT folks if that's an issue. Thinking about cloud platforms, thinking about backup systems and shared folders, because shared folders in particular may not be an obvious resource that people think about because they may not see it as a custodial repository. So that's on an individual level. You also want individuals to acknowledge that they've received this litigation hold notice. And this is all coming from the Sedona conference, which even though I think it's been a few years now since the Sedona conference guidelines for litigation holds come out, they still apply equally regardless of sort of the more nuanced topics that we'll talk about today. And so it's important here to think about this on a more holistic level as we get into specific issues. So next slide, please. As we talked about, the content is important. So identifying the right custodians, which includes folks who may be junior, even if they will be key players. Identifying former employees, especially if information from those former employees is still on systems within a company's repositories, then it is important to identify those former employees and ensure that information is also within the hold. But also in the context when we're talking especially about ESI information, you also want to make sure that you're including administrative folks. And so if you have folks who are managing IT, folks who are managing certain repositories, or for example, Slack channels or Discord channels, it's important to consider whether you're going to be including those folks when you put a litigation hold into place. And then, as I already mentioned, the right sources will be a variety of things. And so when we're talking about pitfalls, people generally tend to recall the typical custodial sources. So email, documents, etc. But custodial sources are also those shared folders that are usually owned by one individual. They can also be the messaging apps and private messages that are between individuals. We also talk about personal devices pretty frequently. And for many folks, they use their personal devices for work communications. And then cloud platforms are also included. But more recently, especially when we're talking about companies that have AI tools, sources might include telemetry data. So logs of when outputs and inputs come in, what kinds of outputs or inputs exist. And recently what we've seen is that there are companies that, because telemetry data can take up a large amount of space, have some pretty strong deletion policies in place. But when litigation happens, it's important to assess those policies and make sure that you're taking a sort of specific approach to which of these resources you're saving, or noting explicitly whether you're not going to be saving certain types of data right off the bat because it's going to be too burdensome. Next slide, please. So common issues we've seen with ESI is that failure to suspend auto deletion processes. There are just a number of ways in which auto deletion can occur. It can happen on an individual level, it can happen on a system-wide level. And so checking all of those different factors when you put a litigation hold into place is important. It's also important, for example, with text messages to talk to individuals and let them know that they need to, for example, if they use ephemeral messaging apps like Signal that are set to delete at a certain point in time, making sure they turn off that setting if they're going to continue using that to talk about communications or talk about issues that are relevant to the underlying litigation. Like I mentioned, system level holds are important, and it's important to involve the right people in implementing those system level holds. Other issues we see with ESI is departing employees. So as I mentioned, there are often custodial files that exist with a particular individual, but they are shared with other people. And so all of those files may exist in a way or format where even when they leave the company, they're accessible to other folks. And so you still need to consider whether and in what ways you need to save information from departing employees, especially when they have things like Slack accounts or Discord or shared files. And then there's also preserving the metadata for various types of ESI. I think Ryan will talk about that a little bit more, so I won't get into specifics of where those issues might arise. And then the other important thing is to make sure that people are not individually deleting, and also consider specifically how you're going to deal with bespoke complex ESI systems. So next slide, please. It's just a reminder that these obligations are ongoing. So it's not just up to in-house counsel, but also outside counsel must monitor and supervise compliance. But also there is a need to update the hold as the case evolves. So if there are new claims, you should update any litigation hold, but also when there's new data sources. So when companies or individuals start using new ways of communicating with each other, new ways of storing information, litigation holds should change when those new platforms come into play. Because otherwise, what we've seen happen is you get to a deposition and a witness is asked about how they communicate with others, and all of a sudden now you have this new platform that isn't on hold, and it has become an issue in the case. And as I mentioned early on, one of the best ways to deal with these issues is to have all of these platforms and your litigation hold set up in advance so that you can be clear about the kinds of information you are preserving, and also what decisions you've made if you've made some decisions not to preserve certain things. expanded time frame should also be included. If there's new custodians, they should be put on a lit hold. But I think now we'll turn our focus to ESI orders and specifically the kinds of issues we see in ESI orders that have come up frequently in the last few years. So Ryan, take it away.
Thanks, Deeva. Yeah, so I tend to think, so Deeva's going to talk, Deeva and Melissa are going to talk a little bit about POs later, but I think of them as working hand in hand, ESI orders and protective orders. Protective orders govern the protections given to information that get produced in litigation, and ESI orders control how you're going to go about collecting information and how you're going to go about producing that information. So as Deeva mentioned earlier on, I work a lot with these orders and sort of getting out in front of these issues and trying to negotiate on, based off of our internal models that we keep. So I'm going to talk a little bit about some of the issues that we've been seeing come up in the last few years as the technology has changed and different footprints, different data sources have come into play. So ephemeral messaging, really things like Slack and Teams and other messaging apps. You need to be thinking about whether or not you should be including that in your ESI orders. And I want to flag like one particular issue here, which is the format of that production, right? Certain systems like Teams store information. When you export that data from Teams, you get every line entry is a singular file. And if you don't reconstruct that into a meaningful timeline, it doesn't make a whole lot of sense. So if the opposing side is producing to you a bunch of information, but it's just one line entry that's completely out of context, think about how that might not make sense to you and why you might want to specify something different, like 24-hour increments or 1-week increments or 1-month increments or something like that. Another issue that's come up a lot is hyperlinked documents or modern attachments. We see that now more frequently. And what we're talking about there is, if you work in a system like, if the system that your company has is something like a G Suite or a Microsoft 365, where you've got these document management systems that are also part of that. So G Suite, you've got Google Drive, Microsoft 365, you've got OneDrive and SharePoint. When we're communicating with each other, or when your employees are communicating with each other, they might just be sending a link to a document and not actually sending the document. So it's not like a regular attachment where, like, if we send a file out, we might attach the file. It's just a link to a document. Hey, go look at this. Those are not captured by standard practice when you export email data. G Suite and O365 or Microsoft 365 now have the ability to include that information. So, and G Suite in particular, I know when you go to export that information, you can specify that you want everything that the user has direct access to or indirect access to. So you want to be thinking about like how you're going to grab that information and what level of information you need to grab in order to meet your discovery needs. And you also want to be thinking about how you're going to create a path for that in the ESI order. Is that something that's going to be an issue in this case? Is it something that's an issue for your opposing party where you would definitely want them to include that? If so, you might want to think about including some language in the ESI order about whether or not that's something that needs to be grabbed in the first instance, or if there's a limited number of links that somebody can ask about or something like that, right? We were talking about, I've already kind of touched on the enterprise messaging systems, Slack and Teams. Those are sort of most prevalent now, Slack in particular. Something you want to be thinking about in the context of drafting your ESI order and determining sources that you're going to collect from and what you need to be thinking about language-wise in the ESI order is a lot of times, particularly for tech companies, your developers are communicating across that infrastructure. And because they're communicating across that infrastructure, that's where your IP is being developed. So if you get an IP claim against you, you need to be thinking about this source. And because you need to be thinking about that source, you need to be thinking about how do we want to go about collecting it? What are the parameters? Which parts of it are going to be considered custodial versus non-custodial? How do we want it produced? That sort of stuff. Which kind of leads me to sort of one of the next bullets, which is distinguishing between custodial and non-custodial data sources. That's also something that we like to do inside of our ESI orders. And we think it's a good practice generally to be thinking about that. If you think custodial data is going to be implicated in the claims and the litigation or not, sometimes it's not. And so you might want to outline that so that everybody's on the same page about what's going to be done and what's within scope in the litigation. Um, Source code. Source code's really hard, a really difficult source for a lot of clients because it's the bread and butter. It's how they make their money. It's how they built their infrastructure. There are a lot of times that you need to be thinking about that if it's going to be in play and how you want to go about producing it. Do you want to just give the source code to the other side as part of a normal production, or do you want to set up some alternative infrastructure for how somebody can see that source code, like a source code computer that's hosted by counsel, where somebody has to come and look at it here and it's not actually leaving the client's infrastructure or the client's outside counsel's infrastructure. Metadata fields and requirements. So this is a big one, right? Like the rules are that you have to produce documents as they're kept in the usual course of business or the ordinary course of business or some reasonable approximation thereof. Most of the time, we don't produce native files in litigation, or you're not expected to produce native files except with certain types of files. And so that means the reasonable approximation is TIFFs, text, and some specified list of metadata fields. What metadata fields are going to be important to you? In other words, what do you need to know about what's coming in? Do you need to know who drafted it? Do you need to know something obscure like the company name for the software, the company name that was entered into the software so you can see if maybe like in a trade secret litigation or something like that, oh, this was created on one of our computers and now they're producing it to us, right? You also should be thinking about families and family relationships, kind of an odd language that's specific to ESI and discovery. But when we mention that sort of thing, it's sort of like an email and its attachment. That's considered a document family. Do you want to ensure that full document families are produced? Or do you want to have some flexibility in how you might break families apart? Do you want to think about junk attachments that are only there that are present because of the data being run through an e-discovery processing tool? Do you want to give some exception on like whether or not you need to produce those? Threading and deduplication, those are both ways to minimize the population of documents that you are going to have to look at, or your document review attorneys are going to have to look at, or that you're going to have to send through some sort of alternative means of review like AI or technology assisted review or something like that. So those are all things that you want to be thinking about as you're creating these ESI orders. And so one of the things I like to think about when I create these for our cases is what's easier, having a little bit of a discussion with opposing counsel now about why something is important to include in an ESI order, or defending a motion to compel. It's way easier to have that discussion up front so that everybody's on the same page. And it also gives you a preview of what issues you might end up having to litigate through motion practice later on in the litigation. When you're thinking about, so I'm going to talk about this slide and the next slide, and I'll kind of move between them. When you're thinking about where to start, right? There are a lot of jurisdictions that have, well, there's not a lot, but there's a few jurisdictions that have model ESI orders. ED-Tax, Delaware, NDCA. NDCA was really out at the forefront of getting some of these models out that people could use and kind of crib off of and begin to build off of. They haven't been updated in a while. I think the 2012, 2014 range was the last time they were updated. And we've had a lot of technological changes in that time period. So what I would say about the model order is that might be a good starting place, right? Like go find a model order from NDCA or Delaware or Texas or someplace where, they have a lot of litigation that deals with these complex e-discovery issues. Use that as your starting point and then really begin to think about sort of what it is that is specific to your organization and specific to the case, like what might be important data sources for the case, both from you and from your opposing party, and begin to build on those model orders from there, right? So maybe like if you were using a DCA, sticking an appendix at the end that deals with how we're going to collect custodial data, how we're going to dedupe things, what are we going to do about source code? How are we going to deal with things like mobile device data and ephemeral messaging. And this is kind of what I was saying a minute ago, like kind of going back and forth between these two slides, right? Like it's really just important to think about those models as a great starting place. Some place you can build off of, some place you can, begin to think about these issues as they go. The other slide had on it, do you get sued frequently enough to keep your own internal model? If you're in litigation on a regular basis, probably. And it might be to your benefit to have that because you can begin to build that out and you can really learn from your cases and your data sources and deal with the specific nuances of your infrastructure, what you see happening in cases. You can really begin to build it out. And the other thing I would say about having your own internal model, I like to negotiate on my terms. I think it's a far better position to be in. So I tend to try to get out in front of this in my cases where we're proposing what we need. And then if opposing needs to add to it or change it, we can have a conversation about that. Like begin to make changes to it to get it to a final place, to get to yes, so we can get it on file with the court. And it does carry the weight of an order. So that is also really helpful. If somebody violates it, you can use the order to your advantage to try to sort of work through whatever issue they have created and what they've done. I think that's it for ESI orders, and we're going to shift to talking about AI and privilege, if I'm correct. Protective orders, sorry. We're going to talk about protective orders and AI.
Oh, so I'll take that one. I want to talk a little bit specifically about how AI tools have come up with protective orders, and in particular, because if we can go on to the next slide. So I think many folks probably know that protective orders typically just allow for the use of confidential material that's been produced in the litigation solely for purposes of that litigation. The whole goal of a protective order is to protect the information that is being produced so that you can limit the use for which an entity can use it. It's to limit information and confidential material and designated material to the scope of that litigation itself. But the problem arises now with AI that a receiving party's use of AI tools can raise significant issues because AI tools send that confidential data to third-party systems and external servers. These AI tools can use data to train models depending on which AI tools are being used. And then there's also a risk of unauthorized retention, disclosure, or reuse of confidential material. And so unlike other third parties, when you have a typical PO, when you send information to a third party, let's say it's an expert or somebody who's a vendor on one of your cases working on PowerPoints, or you might have to send something to the team for an expert, you have them sign a PO acknowledgement that says that they agree to be bound by the PO, that they agree that the use of any confidential material will be solely for the purpose of that litigation. But unlike other third parties, when a receiving party has confidential material and they upload that into AI tools aren't bound by a PO. They don't have to acknowledge the PO's requirements or other limitations within that PO. And so unless the party that's receiving that information and using those AI tools actually takes that into account, and ensures that the same deletion procedures apply, that there's no data being used to train models, that these AI tools have secure external servers and systems, there's no one to really necessarily hold accountable before all of this confidential material becomes particularly at risk. And so the goal of this presentation is not to say don't use AI tools or stop other people from using AI tools. It's to say, think now about what the use of AI in your case looks like, not just for your own case, but also for what information opposing counsel might be putting into an AI tool and how you want to deal with that. Without coverage in the PO, without specifically spelling out this issue, you may lack sort of any kind of safeguards that are contractual or court approved, and then it will be much harder to address after the fact because there may just not be enough information about it. And I'll note that in one of my recent cases, where we were negotiating a PO about AI tools and the use of AI tools in which you could upload confidential material, another entity had not thought about this issue and had entered into a PO that did not cover the use of AI tools at all. And later, when this discussion arose, it became clear that opposing counsel had been uploading material into their AI tools, not just confidential material, but highly confidential material. And none of that had been discussed beforehand. And it was unclear which tools they were using, what security protocols those tools had, whether those tools used the data to train models. So it was important to make sure to do that beforehand because it's much harder to address on the other end. And part of what we'll talk about today is each of these issues is also specific to the AI tools you use. And so when you're working on a protective order early on in a case, you want to consider whether you're having a blanket prohibition, which I think in this day and age is going to be difficult because also many of the tools we use for litigation now have AI embedded in them, Outlook, Gmail, all of these tools that we use, document review platforms have AI embedded. And so blanket prohibitions may not work for a number of reasons, both for practicality, but also if you're considering using those tools yourself in some format. And so what are the prohibitions going to be is really important. And some suggestions may include, for example, limiting use to enterprise platforms. And so we'll walk through those. So questions to ask, next slide, please, is first off, does your protective order require the disclosure of AI tools that the other side is going to use? And of course, if you're asking that of the other side, are you prepared to disclose the specific AI tools that you're going to use? That's a question to ask when you're trying to negotiate a protective order in this day and age. And so what is the procedure for that disclosure? What information is being disclosed? So just asking about the AI tools may not be enough. You probably need to know what version of the AI tool is being used. Is it an enterprise version? Is it closed in some way so that information can't be trained? What kind of security risks are in place? What kind of access provisions are there? Those are all questions that are important to ask, especially when you're dealing with confidential and highly confidential information. The second question to ask is whether you're okay with active versus passive AI tools. And so we've seen courts adopt this language of a passive AI tool being something that, for example, with Outlook, where it's just the use of AI results from merely storing or communicating information through email. That sort of storage and use of AI is not an active input of confidential or designated material. You may want to write that out of your PO because there are a number of tools we all use that integrate AI in a passive way, meaning as long as you're using the tool even without uploading information directly, you will have some AI access to that tool, but it's usually limited in pretty significant ways. The issue is active processing. So if you hand over a bunch of documents that explain core technology, and I think you just heard a number of folks just talk about this on the last call, if there are trade secrets, for example, in that information, now you're putting them into a platform that can actually get into that information and actively process that. It is very important to consider whether your trade secret information or that confidential information will maintain its confidentiality once it's been uploaded. Another issue here is public versus enterprise tools. So in general, what we've seen is folks have been prohibiting the use of public tools entirely. Any tool or model that is public typically tends to train on uploaded data. And that training means that it could regurgitate that data in some way, potentially. Even that potential is enough to be an issue when it comes to confidential information and potentially privileged information, which Melissa will be talking about shortly. Another issue we consistently see with AI use and protective orders is whether the AI platform has the ability to be a single tenant platform or to have private projects. So for example, ChatGPT Enterprise, you can create projects and then those projects sort of are limited to a set of documents that you upload into that project. The issue becomes if somebody is just using a platform where, for example, opposing counsel might be uploading information from all of their cases into the same platform or same project. And now when they might use that to draft ROG responses, that platform has now learned not just confidential information from one case, but also confidential information from other cases. And for example, in patent cases, we see this a lot. If there's a particular plaintiff that's suing a whole number of tech companies, now you have information for competitors that all resides in the same platform and is being used to answer questions, potentially write ROG responses, potentially draft responses to motions, all existing in the same platform where that information is commingled, could potentially be used to respond to queries. And it might not even be evident to the attorney who is asking these questions, and who may not be looking at specific documents to understand which case they came from, which client they came from, and whether that information is actually protected and secure in some kind of way. Audit functionality is also really important. One of the things we've recommended to clients is to require the other side, if they're going to use AI tools, to have audit functionality. And of course, it's not saying that opposing counsel should hand over all of their queries. That's work product. But the issue here is that there needs to be a focus on accountability and traceability. So can the person using the AI tool to review confidential information, do they have appropriate controls? Can they log what's happening? Do they have security features in place so that if something were to go wrong, they could figure out what happened and what information was uploaded by whom and where it went? If those audit functions don't exist, then those are the kinds of tools that you may want to consider not including in the PO, or writing out in some way, or ensuring that there are other ways to meet those requirements. Source code material is particularly an issue. There are many folks who want to use AI now to review source code material. It's important to consider what the impact of that AI tool will be, whether it's air gapped, meaning it's a closed AI model that's only going to work in specific instances on that computer. And then retention policies are also an issue. So for protective orders, for example, they always say when the receiving party must get rid of confidential information. Will those retention policies also apply to information that's been uploaded into an AI tool? How will they confirm or ensure that information is deleted and also not used again in some way because it's been retained by that model? And finally, a number of smaller firms who work in the space are using APIs with their AI tools to have specific functions. We've heard of some law firms that use APIs to basically draft their ROG responses in their first instance. Will those plugins or APIs independently satisfy the same requirements that you have for AI tools? So if you allow someone to use ChatGPT Enterprise because you understand the safety and security features there, do the APIs that integrate into their ChatGPT AI tool also do the same? These are all questions to ask when you're negotiating a PO. And I'll note that a lot of these issues have been resolved by parties up until now in the process of negotiating the PO. I think for many folks, they don't want to be the first company out to be filing a motion to compel with the court on these issues. And it means that we won't have, I think, probably for a little while, a whole bunch of court orders that deal with this specific issue. At the same time, at some point, this is going to come to a head, and we're going to see more and more court orders addressing the use of AI with confidential material. And so while this is changing, the best way to address this now is to think about whether your POs currently cover the use of AI. If they don't, whether an amendment is necessary and what that amendment will look like. I'll really briefly talk about this last issue. So like I said, developing case law, things are changing. The ABA has already noted that all of these inquiries are fact-driven. And so simply saying AI tools in your PO isn't enough. You need to think about what the specific tools are, what their security provisions are, what system architecture exists, and how you're going to address that. And that this isn't just a a sort of looking at contracts and policies issue either. A lot of these conversations mean talking to IT professionals or cybersecurity experts in order to understand what's truly happening with confidential information. As a reminder, these POs exist because they protect confidential information in a really particular way. It's to limit the disclosure of that information. And so what I would advise is that you think about what that means for your particular client or the individuals that you're working with, and what their ability to tolerate risk is when it comes to AI tools, and that also they may want to use. And so it's always a balance. If you want to use AI tools, you'll need to balance that with the tools that you'll allow the other side to use. But then also third-party considerations. So if you're producing material, for example, that is protected by confidentiality agreements, are those parties also aware that their material may end up in an AI tool? Are you reviewing materials that are covered by common interest privilege? Then you need to consider what may happen if you're using an AI tool for that, or if opposing counsel is using an AI tool for that. So I'll pause there. These are all questions to ask, but also there are ways to write your protective order in language that exists in protective orders that you can use here. So I'll let Melissa now talk about the privilege issue specifically, because that has come up quite a few times recently.
All right. Hi, everyone. I'd like to talk today about the recent developments in the law that have surfaced around how the attorney-client privilege and the work product doctrine apply to documents that are either shared with or generated by AI. So as you all probably saw in the legal news over the past month, there have been 2 federal district courts who have made rulings on this issue. And so I'm going to go through each one of them and talk about them, and then we can talk a little bit about ways that we can distinguish them and sort of, maybe some best practices going forward as we sort of deal with this very unsettled area of the law. So the first case I'm going to talk about is United States versus Hebner. And this is a case that's currently in the Southern District of New York. And in this particular case, a defendant, upon receiving a grand jury subpoena and surmising from discussions with the government that he was the target of an investigation, chose to use publicly available generative AI tools to create documents that are regarding his defensive strategies that he later would plan to share with his counsel. He did so without the suggestion of counsel or with any sort of direction. This was all sort of on his own accord and volition. So these documents were seized pursuant to a search warrant, and later these documents were presented to the court, and he argued that they were protected and shouldn't be disclosed because of the attorney-client privilege and the work product doctrine. He argued specifically for 3 reasons why they should be covered by the privileges. His first was that he had input into the AI assistant information that he had learned from his counsel. The second was that he created these documents specifically for the purpose of speaking with his lawyer in order to devise this legal strategy that they would use going forward. And he subsequently shared the contents of these AI documents with counsel. Next slide. And the Judge Rakoff ruled, his holding was that the defendant's communications using publicly generative AI assistants done without the direction of counsel were not protected by the attorney-client privilege or the work product doctrine. As to the attorney-client privilege, he gave 3 reasons why they were not protected. The first was that they were not communications between Hebner and his counsel. So the court really framed this issue as Hebner having a discussion with an AI assistant, and the AI assistant was not an attorney. And so this was a conversation between 2 non-attorneys, and thus not protected by the privileges, or by the attorney-client privilege. The second reason was that these communications weren't confidential. So Judge Rakoff first cited to the fact that when you communicate on a AI assistant platform, you are inherently having a conversation that is going to be available in some form or accessible by at the very least back-end administrators who can access that information. But on top of that, Judge Rakoff cited to the written privacy policy that the AI company had in place that Hebner had consented to. And he pointed out that the privacy policy stated that the company had the ability to retain all the data, both the inputs and the outputs from the AI assistant, it was able to then use those inputs and outputs to train the LLMs, which could mean that the information could then later be disclosed in some format to others based on that training. The written privacy policy also allowed for the disclosure to third parties, especially to law enforcement and to other government regulatory authorities, which was another reason that Judge Rakoff reasoned that Heppner had no reason to believe that these communications would be kept confidential. The third reason was that he did not communicate for the purpose of obtaining legal advice. And this was a closer call for Judge Rakoff than the other ones, because the Heppner had said that he did use the generative AI tool for the express purpose of talking to counsel. But counsel didn't suggest it, didn't direct the use of AI. And so it wasn't operating in the same way that you might think of other document processing software like Google Documents or some sort of discovery platform that we sort of think of as acting as a tool or a lawyer's agent in helping. It was really more of a communication with a third party. And he also noted, as we all know, that you cannot transform non-privileged communications into privileged ones just by sharing them with counsel. So next slide. Oh no, pardon me. Let's go back to the next slide. I also want to talk about the work product doctrine. So he also had stated that the work product doctrine did not apply here. That was because these weren't prepared by or at the behest of counsel, and he'd done so on his own volition without acting as a counsel's agent. And the other reason was that these documents that were generated by AI did not reveal any sort of counsel strategy, legal strategy, or mental impressions. So the lawyer conceded that the documents did affect his legal strategy going forward, but that they did not reflect counsel's strategy at the time that the documents were made. So the work product doctrine did not apply either. Okay, now we can go to the next slide. This is sort of, in contrast, this case was actually ruled on the same week. And this case is Warner v. Gilbarco and took place in the Eastern District of Michigan. And there, a pro se litigant used AI in preparing documents for litigation. And the defense brought a motion to compel, arguing that they were not privileged. And the court there held that the documents were protected, even though they were technically viewable to like back-end third-party administrators of the AI company. It's unclear from the case itself whether this was a publicly available AI tool like Heppner used in his case, but nevertheless, the court held that the work product doctrine here did apply. The materials that were sought were the pro se litigant's internal analysis and mental impressions, which go to the sort of the heart of the work product doctrine. The court said that even if the other side had argued that if it was protected, it was waived when it was used with an AI source to create these documents. And the court said, no, the work product doctrine is broader. And just because you share these communications with the AI assistant does not mean that they're going to be shared with an adversary. So it's not likely. So that also is not a basis to strip this person of work product doctrine. And then the last was that this is just more of a thematic thing that sort of pervades this case versus United States versus Heppner, is that Judge Patty really saw this, in Warner, saw this case as AI as a tool that would be used just like other tools are used in litigation in the modern age, like document review software, dictation software. It was not seen in the same way that Judge Rakoff saw AI, which was more of like a almost human-like interaction and having a conversation. And it will be curious to see as we go forward sort of how courts will grapple with this idea of whether you are sort of communicating into the either of a potential conversation with this human-like entity versus using AI as a tool. Next slide. So there are a few things that really stood out in these cases to sort of think about as we think about what would be good best practices going forward. One is just that, especially Judge Rakoff was very clear, like this was a publicly available generative AI platform where it was much more likely that the information input into the system would be used to train the system itself and was more likely to be disclosed to others. So that is something that was a big distinguishing factor that I think could matter going forward. AI platforms Their privacy policies also matter here. Judge Rakoff really focused quite a bit on the disclosure to third parties, the use of training, the retention policies all mattered here. And the other, which also I think is sort of the biggest sort of hinging factor, it seems, is the AI use, whether the AI use was directed by counsel or whether it was done on the client's own volition. So the more likely it is that the counsel directs any sort of AI use, the more likely it is to be protected by the attorney-client privilege or work product doctrine. And the more likely it is that it's just a client going out and doing their own legal research or inputting their own information into a generative AI tool, the less likely it is to be privileged. And thinking about AI use and how it's operating. Are you actually having a conversation to understand the law and get legal advice from the AI tool, or are you using it more like a third-party aid or some sort of other tool that could be used going forward? Next slide. So I guess the question now is, so what should we do with this information? These are the first two cases to consider AI and the attorney-client privilege, and it's a developing area of the law. We know that these cases aren't binding anywhere, but they likely are laying a foundation for how judges are going to think about AI and these privileges going forward. And so it would be good to take some lessons from here about how we can set ourselves up for success to not sort of fall into these traps and inadvertently waive privilege or disclose information that was not intended to be disclosed. So the first consideration as sort of a blanket statement is that assume that things that are input into AI, whether they be the prompts or the actual documents that are being uploaded into the system, are discoverable. That means that, as we talked about at the very beginning, Deeva had mentioned that litigation holds are going to come up here, and you need to think about, even before you are in litigation, what does it mean to retain the AI prompts and the AI information that you have? And then once you do have a litigation hold, what is your obligations with respect to all of the use of AI that you have in your company or at your firm? You're also going to need to think about, as we've just talked about throughout this thing, how AI prompts AI prompts and AI outputs are going to be discoverable. And so we need to be thinking about that going forward. The next thing you can do if you are in-house or at a firm is to adopt a written AI use policy that really is specific. It shouldn't just be something that's general of use AI responsibly or carefully. It really should specify details of what AI sources can be used. How are you going to approve which ones will be used? What categories of information can be input into those systems? What will be your retention policies? Who is responsible for vendor review and cybersecurity related to them? The more holistic you can be, the more likely you are going to protect yourself and not have employees using some sort of either publicly generated AI tool or something that is basically is going outside the box and is more likely to disclose confidential information or information that is arguably privileged. You're also going to want to understand what type of AI platform is being used by your client or if it's at your company that you work for if you're in-house. So understanding, is it a publicly available one that anyone can access, or do you have your own enterprise tools? Do you have a retention policy around how long you retain these prompts? And or do you have, if you are using a publicly available one, do you have ability to opt out so that so that the information that you input into those systems is not being retained and then used to train the LLMs in the future? You'll want to look at the privacy policy around it. And you'll also want to look at third-party disclosure. If the company retains the right to share the data with affiliates, law enforcement regulators, that will be an important point to note going forward. And you'll want to inform your clients about the risks. So you'll want to inform them both about independent legal research. So thinking about when your client is trying to figure out what are these defenses that I might have in this case, or if this is a true fact, what would we do? Or what is the regulatory policy around here and have we complied with it? Really limiting the amount that your client is using AI for legal questions is important, and you should inform your clients about the risks early. Same thing with inputting confidential or privileged information into AI. If AI outputs and inputs are discoverable, we need to think about what do we actually want being put into the system, and if we are putting confidential and privileged information in there, how are we protecting that information with the type of system that we're using? And last, once you've gotten into litigation, you should really think about making any sort of use of AI attorney directed and documenting to the best of your ability that direction so that you can go back and say at any point, oh, my client used this for AI because I directed them to do this. And I supervised that work and I reviewed the output. I defined the tasks. That way you are creating these guardrails that make it so that it's more likely the court will find that any sort of client use of AI will end up being seen as attorney directed rather than on the client's own volition. So with that, I think we can open it up for a few more minutes with any questions that anyone might have about e-discovery.
Yep. And I'll just note these issues that Melissa raised, but also we've talked about throughout this presentation. There is no company or entity or firm that is too big or too small to have to deal with these issues. They are going to keep coming up. And so these are issues to think about now and think about at the early stages of your case instead of at the stage where you're now doing individual motions practice about each and every single one of these issues. So any questions?
Okay, I don't think so. I will move everyone into breakout. Oh, there's a question. Do you have a standard form to use to protect the clients in these types of instances that you could share?
And Gerald, I'm not exactly sure which specific instances, whether that's specific to the AI stuff or ESI. We don't necessarily have a standard form that we can share because I think a lot of this advice is going to be specific to the tools that your entity or that a particular firm uses. And so we don't actually advise you to use a standard form that isn't tailored to the platforms that you all use, because I think that can actually create a lot more of an issue. I will say that there is now some protective order language. There's like a Tesla case out of Texas that has an example of protective order language on the AI issue that's worth looking at. If that's an issue, I think if you do have counsel, it's important to sort of ask them exactly what language you should input, because it might also impact the counsel that you're using, or it might impact sort of if you're at a firm, the other people that you're working with. And so I don't have a template or a standard form, part of the reason being that people also have different risk tolerances about whether they're using AI, for example, and so they don't want to limit the use of AI from other folks, if that's the issue that you're getting at. Great. Thank you all very much.